I'm not a lawyer, but Attorney Love from the YSL RICO trial just filed a response to the motion to recuse Judge Glanville, and I read the response, so let me recap it for you. If you recall, the response from the state was due by 5 p.m., and it looks to me like it was filed at 5:42 p.m. Let's get to the response. Early on, Ms. Love makes it clear that though the defendant's motion and supplement are in part timely, in part as in partly on time and partly not on time, and the affidavits in support of the defendant's motion and supplement are in part again, legally sufficient, none of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. Oh, so she's saying even if what they're saying did happen, it's not enough for him to be recused. Defendant's motion and supplement should therefore both be denied. She goes into the factual background, saying that on June 6th, the state announced that they had plans to call Kenneth Copeland the next day. After that announcement, they, meaning the state, received an email from Jonathan Melnick claiming to represent Kenneth Copeland. And here she says, quote, perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectively by Brian Steele and Max Shart, Melnick copied Brian Steele and Max Shart on this communication with the state regarding Copeland's intention to testify. Y'all catch what she's trying to say? She then goes into how she presented a motion to Judge Glanville to compel, aka force, the testimony of Kenneth Copeland by giving him immunity and holding him in contempt should he refuse to testify. Attorney Love then goes into the rest of the day. She says how Woody said he would testify. At that point, according to her, Mr. Melnick looked toward Mr. Steele and Max Shart and shrugged his shoulders. Attorney Love continues on, saying that Woody pleads the fifth on the stand, he goes to jail, and then she says that following Monday morning, prior to the start of court, the state themselves requested from the court an in-chambers meeting with counsel for Kenneth Copeland himself, the court, and an attorney for the state to discuss the contempt proceedings initiated against Kenneth Copeland upon the state's motion. So that confirms what we already knew to be true, that the request for the ex parte came from the state. The court granted that motion, so they had the ex parte. The court reporter made a record of the meeting, and then she lists all the people who were present in that meeting. Regarding that meeting, Attorney Love says, quote, matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included Mr. Copeland's right and representation as it relates to the proceedings, Mr. Copeland's obligations based on that immunity, and answers to questions posed by Mr. Copeland regarding matters related to the immunity and contempt, such as a distinction between purging oneself of contempt and perjury. She also says, with the exception of the times where Mr. Copeland was afforded an opportunity to speak to Ms. Bumbus alone, the entire meeting, according to her, was taken down by the court reporter. The next section of this response she titles as Brian Steele's defiance of the court's commands and subsequent contempt ruling. In this section, she says, quote, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at Chief Judge Glanville accusations of misconduct. Most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's commands to reveal Mr. Steele's source of information regarding the in-chambers matters. And then here she gets to why she says that motion should be denied. She says, quote, to be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in the case. There is a presumption that a trial judge, acting as a public official, faithfully and lawfully performs the duties devolving upon him. In layman's terms, according to her and what she's quoted, for a judge to be considered biased, that judge has to have received information from a source outside of the trial, and that information has to result in them forming an opinion and therefore influencing how they handle or make decisions against one side or the other. But I'm not a lawyer, so if I misunderstood that, chime in and let me know. And that judges are presumed to be fair and lawful, so to prove that they are acting biased requires more than just how they make decisions in a trial. And Attorney Love says that Brian Steele's motion to recuse Judge Glanville is entirely based on the defense says happened on June 10th in that ex parte, versus what she said in the previous paragraph, that it has to come from something extrajudicial. In the next paragraph, she says that the Georgia Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. However, No defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motion of the state. Since no defendant in this case had a right to be present at the June 10th, 2024 ex parte, the facts of that meeting provide no grounds for recusal of Chief Judge Glanville. Basically, they didn't have a right to be in that meeting. That meeting was none of their business. And so that meeting can therefore not be used as the reason for the judge to be recused. That's her argument. And she also included the infamous FU email from Melnick. It says, quote, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. Put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client." That felt a little different than just straight up F you to me. So now we wait. Will Judge Krause recuse Judge Glanville, or is Attorney Love's response strong enough for her to deny the recusal? What y'all think?